You are welcome to Company and Partnership Law class. Today we look at Unit 2, Section 1. Unit 2 is on nature and functions of companies, and Section 1 of Unit 2 is on history of companies in Ghana and the pillars of company law. Now, the session objectives. By the end of this session, you should be able to explain the 3 pillars of company law. Also, demonstrate an understanding of the company law theory and discuss the history of company law in Ghana. Now, let's look at the pillars of company law. The first pillar you consider is the Companies Act, which is the Companies Act 2019, Act 992. This act is the primary source of law that any issue about companies will be used to deal with that particular issue in question. So when there's a dispute in a company as how certain things should be done, you will fall on the Companies Act 992 to resolve that issue in question. So you should note that the primary source of company law is the Companies Act itself. Now, another pillar that you have to consider is the judicial decisions regarding corporate disputes, what you normally call the case law. The case law. Case law simply means decided cases. So when there's a dispute that comes before the court will adjudicate on that matter and pronounce judgment. The judgment, if it is being given by the superior court or superior court, it becomes a precedent, and all other courts below that court will be bound by those cases. A typical example is the case of Solomon v. Solomon. The case of Solomon v. Solomon established the principle that a company is a separate legal entity, distinct from those or the promoters who incorporated a company. It can sue and it can be sued. The case of Solomon v. Solomon established this principle. Also, if you look at the case of Royal British Bank versus Tarquin, this case also established the principle of the internal management rule and the presumption of regularity. What this means is that third parties dealing with companies should assume that those officers acting on behalf of the companies have the authority to do so, and they don't have the duty to ascertain whether or not the officers have complied with the internal rules. Now, you also have the case of Force versus Harborton, where it deals with the majority rule. It means that the majority decision will take precedence over, or majority decision will have priority over the minority decisions. Now, you also have the last pillar, which is the company theory. The company theory explains why and why not of the law as the court interprets certain provisions. They may fall on academic writings or academic tests, and also reports of various commissions. So, for instance, the Gowers report is one of the key reports that we may refer to when we want to interpret some of the provisions of the company law. Now, let's look at the history of company law. The history of company law in Ghana has been dealt with substantially in your manual. However, what I intend doing is that I want to bring it to your attention the key elements that if you are reading, you don't have to forget. Now, let's look at the initiatives in the evolution of company law in Ghana. Now, the starting point is the Gowers report, which is 1961, and the resultant Companies Code 1963. This Companies Code of 1963 has been repeated by Companies Act 2019, Act 992. Now from there, we had the CRAB Bill, which is 2003. This was also a report to ensure that amendments could be made to the Act 179, which is the old Act. Now, we also had the Gates Committee report in 2016, then the Taban's Committee report, which was 2008. Now, all these reports were to ensure that amendments could be done to the old Companies Act 1963 at 179. Now, you have to know that by the mid-19, companies were established in one of three ways. So, in the olden days, specifically the 19th century, companies were formed by royal charter. If you don't use that mode, you go by an act of parliament or special act of parliament. If not, you go by registration. So these were the key method or ways in which you could have incorporated your company. Now, you want to know the right to form a company. Who has the right to form a company? Can anyone at all stand up one day and form a company? The answer to this question can be seen from Section 6 of the Companies Act. So, 2 or more people can form a company. How you have to know that because of contractual issues, those who are 18 and above have the capacity to enter into a contract or incorporate a company. So 2 or more people can form a company, notwithstanding that a single person can also form a company per this provision. Now, the locus classicus on incorporation of company is Solomon v. Solomon. What we mean is that the right to form a company can only be supported by the case of Solomon v. Solomon. So, the case of Solomon v. Solomon established the principle that a company is a separate legal entity when it is incorporated. Once it is incorporated, it assumes a character of what? Artificial person, capable of doing all businesses that a natural person would do, provided the contract is not illegal, but rather lawful. By way of summary, in this session, we learned that company law has 3 aspects in concern, and these 3 aspects are the 3 pillars, which is the first one, the Companies Act, the second one, case law, the third one, company law theory. We also look at the history of company law. Thank you for your time and see you in the next class. Goodbye.